Hello and welcome to Hull & Hull TV. My name is Ian Hull, a partner at the firm of Hull & Hull, and I'm joined here with our managing partner, Suzana Popovic-Montag, and a friend and colleague, Jordan Atin. At Hull & Hull TV, we canvass issues relating to estate, trust, and capacity law. Today, with our special guest, Jordan, we're going to continue to work through the difficult challenges that come from taking time with your client to prepare a good, comprehensive, and sound estate plan for the family. Jordan, after you've gone through the hard work of looking at your client's issues, considering them in the context of their family dynamics, you've created the document, you've had them sign it. What do we do with this very special document?
Right. It's often a very big concern for the client. It's often the question that they ask me. Well, it's important to keep it in a safe place. The original document is important. You can put it in a safety deposit box. Some law firms keep the original will for the client. The idea is that you're going to eventually need the original will. And so I caution clients, put it someplace safe and let their executors know about where it is.
You know, it's interesting to me in this day and age of less paper or paperless. This will document and power of attorney document are two documents that you need the originals for.
Correct, yeah.
And Suzana, is it a fatal blow to your estate plan if you die and you cannot find your will?
No, it doesn't necessarily have to be fatal, believe it or not. There is a mechanism if you can't find the original will and you're pretty sure that it should have been in existence and simply can't be located, you can go to court and you can prove a lost will. It's an application that unfortunately is going to be expensive. It's going to be time consuming, but it certainly is a means by which you can recreate a testamentary document for an individual.
So, Jordan, coming back to your practice, and many solicitors certainly follow that similar approach that you take, I know. With this original document, do you give the clients the original? Do you give them the copy? What is your personal practice?
My practice is I don't hold original wills. So I will give the original back to the client and I will confirm that I've delivered the original, because often people are like, who has the original? So I'll confirm that, and then it's the client's responsibility to put it in a safe place, and I give instructions on some suggestions where to put it, but it is up to the client to maintain that.
Suzana, what happens if you're in a fight to chase down that original will and you're in a contentious environment? What kind of steps can you take?
Well, fortunately, again, we can look to the court and you can bring an application compelling someone to bring a testamentary document before the court. And here in Ontario, under our Estates Administration Act, there is that means by which you can actually compel someone to bring it into court.
Thank you very much, Suzana. And thank you to you, Jordan, as well, our special guest.
Pleasure. Thank you.
We are always hopeful that when someone passes away, it's an easy transition, that the will get into the hands of the proper people and the estate will be administered smoothly, but it's comforting to know that the courts will step in from time to time if necessary. And thank you all for watching Hull & Hull TV and joining us for this episode.